Welcome to the final working group plenary session of this year's annual conference. Before we dig in, I would like to take the opportunity to applaud our gracious hosts, Connie and her team, her amazing team, for un buen trabajo, for an excellent conference and social events. Thank you very much. Let me briefly, in the interest of time, introduce our amazing and esteemed panel of speakers. To my immediate left is Ms. Marisa Tierno, who's the Director General for Competition of Spain's National Markets and Competition Commission. To her left is Mr. Jorge Grunberg, the National Economic Prosecutor at the Chilean National Economic Prosecutor's Office. To Jorge's left is Ms. Amira Ashraf, who oversees the antitrust and competition practice and is a partner at the Wong Partnership in Singapore. And finally, Mr. Manish Kumar is the Deputy Assistant Attorney General for Criminal Enforcement at the United States Department of Justice Antitrust Division. So we have a great panel for you today, and we're going to sort of take things sequentially through the cartel world. And let's start by talking about some current trends, particularly in detection. I think everyone in the room probably agrees that detection is important both for uncovering cartels generally, but it also provides incentives for applicants to apply for leniency if there is a credible risk that agencies will detect their conduct. This, of course, makes proactive detection, ex officio detection, even more important in the current environment where we are seeing a decline in leniency. So let me go first to Manish. Manish, can you tell us about some of the ways the United States is proactively generating cases right now?
Sure, it'll be my pleasure, Matthew. And let me join you in thanking our hosts at the CNMC for just a wonderful conference over the past few days. So I think sounding on a theme for this conference as a whole, one of the things that we have been really pursuing at the US DOJ is international cooperation, the reason that we're all here. We've made it a priority to try to engage with our international partners in order to share intelligence, identify potential cases, and really try to work with one another to use each other as force multipliers in our investigation and prosecution efforts. So I'll just briefly highlight two initiatives that demonstrate our attempts to do this. The first one is a joint initiative that we are pursuing with your agency, Matthew, as well as our colleagues in Mexico in connection with the 2026 World Cup. And that sporting event will be hosted at a number of sites across North America and in all three of our jurisdictions. And so in connection with this really important event, we anticipate a massive influx in public spending in order to construct the necessary facilities and infrastructure to host these games. And as we all know, when we see large amounts of government spending, especially over kind of a abbreviated time period, that often creates conditions that are ripe for collusion. And so our initiative with Canada and Mexico is attempting to extend outreach to various public and private entities that may be either vulnerable to collusion or maybe witnesses to collusion. And secondly, just to strengthen the channels of communication that we can have with one another to try to use each other as force multipliers to identify potential cartel conduct. Similarly, we've been working with a number of enforcement partners through a regular series of meetings to identify issues involving collusion in our supply chains. This was occasioned by the supply chain shortages that all of our economies experienced during the COVID-19 pandemic. And we have used these meetings as a forum, again, to share intelligence, to share information about investigative techniques. And so these are just two examples of the ways that we're trying to engage with our fellow partners, many of whom are in this room, and I'm very appreciative of the conversations that I've been able to have with all of you in order to try to respond to a changing economy. So that's a little bit of my perspective on some of the issues that we're confronting.
Thanks, Manish. Canada, very happy to be working on the World Cup initiative. It's great. It was great to send out that message and alert the community across North America that all three agencies were going to be on the job and letting folks know that they can contact us. In both Spain and Chile, there have been some really great initiatives over the last couple of years to advance your proactive work. Perhaps I could turn to you, Marissa, and you could talk to us about some of the things that you've done and some of the great advancements that have been made.
Yes, well, actually, ex officio detection is for us a strategic priority in cartel detection. And in 2018, we created I think that by now you all know our economic intelligence unit. So it was created in 2018, and also at the same time, the legislator made compulsory for public bodies to make all tendering in Spain through electronic means. And that was an opportunity for us to try and investigate further bid rigging. I will come to the instruments that we have been developing, but I wanted to say that in our statistics, since 2018, 70% of the cartel cases we have had have been triggered by other means than leniency. That doesn't mean that leniency didn't come in, because in more than half of the cases there was at least a reduction of fines due to our leniency program. And then another around 70% of our cartel cases related to bid rigging. It is not the same 70% necessarily, but they overlap. So it means that we are really having a good ratio of ex officio cases. So the first steps that we took were what you have heard in the breakout sessions. Getting the data is not enough. You also have to clean the data. You have to be able to use them. They have to be structured. If they are not structured, you have to do something to get them structured. So the fact that we had the public tendering available, the state public tendering and the regional, and that we were going to make our own database of those data, is not that easy, because normally when the public bodies are tendering, what they care about is the winning bid. But what we care about is the whole constellation of the bidders. So we need to have the losing bids, and we need to know whether there are patterns of behavior. So often these documents were available in formats that were not useful. And therefore, within our economic intelligence unit, we devised a way to read those documents and to be able to make structured data out of unstructured data. Anyway, so we have this database that is updated all the time, and then came the next breaking event in the unit, which was to create a kind of Google, for you to understand me, to be able to search easily within the database. So it's the same procedure, you know, with the box where you can type normally and you can find things. And that was already a quite interesting development. But now we have also come with a tool that is still being tested, but in the test we are giving an accuracy between 90 and 96% of good predictions of whether a tender is likely to be competitive or not competitive. And this has been done with the help of machine learning, cluster learning. And I think that the high ratio that we have is due to the fact that we have included more parameters than has normally been done. So of course we don't only have the database of the public tendering, but we also have access to registries of property and to different data. But we have been using new keys to search. And well, not to go too long on this, I wanted to say as well that we think that this will enable us for the first time to do really pure ex officio. I mean, then you still have not only to detect, you have to prove, you have to stand in court, you have to get your warrant order. So it is more difficult than that, but that is going to be a special event that we want to now test in reality. We have tested it with our old cases, and the results are the ones I was mentioning. And then, very briefly, we also have a channel for whistleblowers that has been in place since 2021. We call it SICA. It is an anonymized and encrypted channel, so we can communicate back and forth with individuals without them necessarily giving away who they are. And this has been given a very good ratio of tips. So we have on average around 170, a bit more, whistleblower entries. We have been looking closer to around 30% of those, and we have initiated, we are investigating more deeply, like 10% of that, which I think is and that is the same unit who is in charge of that. And then the last point that is also new, recent, and it's very interesting, I think, for other agencies, if you can get it, is the fact that the public contracting law includes some provisions of either obliging or giving the opportunity to public contracting bodies that have suspicions about this kind of conduct, that there is something strange in the tender, they see how people react, to bring it to the CNMC and obtain a reply from us. Do they always obtain a reply? Well, if we see that something is very serious and it is widespread when they make the analysis, then we don't always react in writing to tell them there is a problem, because maybe we want to have done rates and find something more. And then what we are doing is that we are training the officials that are doing this public tendering so that they are able to detect the signs of collusion. So that in a nutshell is what we are doing.
Wow, okay, thank you. Lots of deterrence in that too, for people in the Spanish community not getting into bid rigging if you have these great tools. So that's excellent. Jorge, what about proactive detection in Chile?
Mm-hmm. Thanks, Mario. Good morning, everybody. Well, Chile has a strong track record in ex officio investigations. Our leniency program works well, but as it happens in other small economies, our cartel detection and prosecution capabilities have never been leniency dependent. Since the introduction of the leniency program in 2009, I must say that only 36% of the cartel cases we brought before courts had a leniency applicant. Our rates securing convictions in cartel cases are the same with or without leniency. And during the same period, more than 50% of the cases we brought before courts stemmed from ex officio investigations, without complainants or type A leniency applicants. That said, we have been occupied in maintaining and increasing our proactive detection capabilities. Following the example of other agencies, we created an intelligence unit back in 2018. Even though we are just starting with this unit and we don't have as much resources and staff as we would like to, we are beginning to see the first results. In the process, I believe we learned two lessons that would be especially interesting for smaller and younger agencies like mine. The first lesson is when we talk about intelligence in panels like this, detection is often presented as sophisticated combination of algorithms, big data, and artificial intelligence. This could definitely intimidate and deter younger and smaller agencies from engaging in data intel. We have learned that there are lots of simple things agencies can do to gather, order, and process data to detect illegal conduct. And the second lesson is that international cooperation is key in this area. We have been lucky enough to find support from many agencies with more experience than us. This is something the Cartel Working Group wants to promote by creating a framework for information sharing on data analytics, which is basically a contact list of data scientists and investigators working on bid screening and other types of data analytic tools within agencies to increase collaboration on this topic between Cartel Working Group member agencies. Finally, I want to say a few words about our leniency program. We have been hearing about the decline in the number of applications years now. However, some green shoots seem to be appearing here and there, with many jurisdictions reporting an increase in the number of leniency applications. We are definitely facing a similar phenomenon in Chile. Our leniency program looks particularly healthy. I would like to say that our leniency program has room for 2 applicants, and both companies and individuals alone have been applying during the last year. I cannot get into details about the figures because cases are still not public, but I'm confident this year we will have an all-time record of cases with conditional leniencies granted this year. That is our perspective.
Thanks, Jorge. That's like a perfect segue to Amira, where I understand that in Singapore recently, leniency applications are very much on the uptick. I don't know if I'm overstating it, but that leniency is making a comeback in Singapore.
I guess you could say that. To preface, I think it's important to understand that the number of leniency applications are necessarily quite small, no matter what, even if we have an increase. Singapore is a small, open economy, and with fines based on turnover, the fines are necessarily small, which means that particularly for MNCs, there might not be that incentive for them to come forward because they might think, well, the fine is small enough, I can manage it. It's not likely to be in the top 10 number of countries that it would seek leniency, even where there is a local impact. So the number of cases, particularly for MNCs, is generally low. And we, like Jorge, I think we had some concerns due to developments elsewhere that the number of cases seemed to be declining, and certainly during COVID, that was, I think, close to 0. However, you know, as they say, the reports of death greatly exaggerated here, and we have found, particularly this year, there have been these green shoots that Jorge talks about. First of all, I think we have seen a few MNCs come forward. I think that's particularly due to MNCs which have Singapore as their headquarters in Asia or have some strategic importance where they feel they need to appear to be a good corporate citizen. So we have seen some applications, not many still. Where I think it's more interesting is what the Commission in Singapore has done with the local cases, because we have also seen more local leniency cases come forward. I think a couple of years ago, the Commission did a survey on businesses and asked them about the awareness of the leniency program, which was an astonishing, I think, 10% or something like that. So the vast majority of businesses didn't know that there was a leniency program. And what the Commission has consistently done is outreach. Amazing outreach. I think they really pound the pavement. So you can see them at, business fairs. They have their own booth. They offer to speak. They have Facebook, Instagram. They don't have many followers. So if you all want to do them a solid and follow CCCS_SG, please do so. They have a YouTube video on leniency. They've done all they can, I think, to offer this outreach to local businesses such that they are aware of this program. And I think that, you know, because of this outreach, it has made it easier for leniency applications to come forward. As an aside, in Singapore, even if you are the instigator, you can get leniency. You just can't get 100% immunity. So you can get a reduced immunity. All of this action, I think, has led to more local businesses coming forward to try and get leniency.
So a successful initiative in terms of promoting compliance and awareness across Singapore. Okay. Okay, that's great. Well, let's turn to another important aspect of our cartel enforcement work for all of us, which is deterrence. It's been argued that corporate sanctions in many jurisdictions may not be high enough to be an optimal deterrent against cartels, and that, of course, deterrence can be enhanced by the ability to pursue individuals. And I understand, Jorge, that you folks in Chile recently were given the ability to pursue individuals for cartel conduct. How's that working out? What's going on there?
Okay. Well, for decades, we only administratively prosecuted companies, even though it was legally possible to prosecute individuals. We didn't do it mainly to avoid the complexity involved in investigating and particularly litigating simultaneously with several companies and individuals, both before the competition court and before the Supreme Court. But in recent years, after we proved to the legal and business community that we were effective prosecuting administrative cases, in fact, we haven't lost a cartel case in court in a decade. We started prosecuting individuals. Even though it has added complexities to our investigations and trials, we believe prosecuting individuals is a very powerful tool to deter decision makers from engaging in unlawful conduct. In one recent case, in the market for the transportation of money and valuables, we even decided to prosecute regional managers or of multinational companies who didn't have residence in Chile. These regional managers oversaw the business in Chile and other countries and actively participated in the cartel. As I will explain later, this involves several international issues where we believe enhanced international cooperation is necessary. In a different case involving the aerial firefighting market, just a few months ago, we got the first court decision from the competition court sanctioning the general managers of two companies involved in the cartel and making, this is interesting, one of them jointly and severally liable for the fine imposed to his company for an amount of $2.2 million. This case is now under review before the Chilean Supreme Court, but we hope to succeed in this proceeding.
That's got to be a significant deterrent to be jointly and severally liable for, did you say $220 million? Yeah, okay, for an individual. Marissa, you folks in Spain have been doing individual sanctions since the 2015, I think. What have your experiences been with pursuing individuals?
Yes, so the possibility of finding individuals was there in the law since 1989.
Okay.
But it wasn't used until there was a judgment of the Supreme Court encouraging us to actually use individual sanctions. So after that moment, we started doing it, and since then there have been 73 individuals fined in 13 cartel cases with a total amount of 3 million euros. And 31 of those individuals are of the last 3 years, okay, out of 73 that I have mentioned. So you would say, but it is not so many individuals if you count the amount of cases. It's because it's not any individual that is participating. It has to be a person in the management. There has to be special situation for that. I will come to that in a moment. But I wanted to highlight that, okay, the fine for individuals is 60,000 euros, which in itself maybe is not always as deterrent. There was a project that maybe passed by the parliament once we have fixed the new government, I don't know, in the future was to raise the amount to 400,000 euros per individual. We will see what happens there. But I want to highlight also the fact that beyond the fine, there is the publication of the name of the persons who have been involved and who have been fined for that. And I say this because there is also some deterrence in the fact that their names are known. And this was an issue that was brought to court because companies, the lawyers were coming forward to say you shouldn't publish the name because there is a question of privacy. And this happened in 2017, and then first the Audiencia Nacional, which is our High Court, confirmed that it was in the public interest to know who was infringing the law, so even if they were individuals. And then it went to the Supreme Court in 2019, and the Supreme Court clarified that the right to privacy was not at stake because we were speaking about conducts that were taking place as professionals. It was not part of their private life. Okay, and then by the same token, it was made clear what was the kind of participation that the individual had to have in order to be able to find it. And then the court was comparing this with an obligatory or a compulsory participant. It's a bad translation from Spanish, but what I mean is that you have to be not only directly involved in the infringement, but you have to have been essential for the infringement so that the infringement wouldn't have happened if you wouldn't have been involved. So it's a high standard, and it means that you have to be in management, either you are a legal representative or you are a person of the governing body of the company, and then you could make the decision or you could contribute to the decision in a way that would be decisive. So that's why we have as many as we can, but we don't have all the possible that you would consider. Next to this question of on the involvement and the number of, and the fine, I wanted to say that there is also leniency, of course, for individuals, not only for companies. And up to now, we have had 4 individuals that have been granted immunity from fines and 2 which have had their fines reduced. And just to finish on this, we have seen we have seen the way companies have reacted to individual penalties. And then at the beginning, I think that what happened was that the companies were paying the fine of the individual. And that was it. But nowadays, because of the importance of compliance, and I will speak about compliance in another moment in this panel, then one part of compliance is that individuals take the fine and take the punishment, and eventually that they are fired or that there is action undertaken against them. So this has stopped, and I think that it is a good development, and all in all, we consider that it must be something that helps to deterrence.
Yeah.
So,
an additional sanction.
Yeah.
So, Jorge, before you were talking about the pursuit in the administrative cartel part of Chile's law, but you also have a criminal cartel provision, and also, I understand, a new white-collar crime law this year. Can you just bring us up to date on how you've used your criminal cartel provision and what might come in Chile with this new law?
Sure. Well, let me first start saying that cartel conduct was criminalized in Chile in August of year 2016. We haven't had criminal cartel cases yet, as our system requires full administrative prosecution before referring the case for criminal prosecution. However, currently we do have cartel cases under litigation before the competition court that could be definitely later be prosecuted criminally. Criminalization brought some important challenges to our investigations that I would like to share with you. First, The first challenge is that we reviewed our evidence collection procedures to make ourselves sure the evidence collected in our investigations was going to be usable in a criminal procedure. Even though it was an interesting exercise, we concluded that most of what we were doing before was compatible with the standards imposed by criminal procedures. And the second challenge is that even though our procedure remains an administrative one, we knew we were going to hear parties invoking criminal procedure constitutional rights in our investigations. We examined this very carefully, sharpening our understanding of the interplay between administrative and criminal procedures. And on the new white-collar crime law that you were making reference, Matthew, it is important to note that well, it was enacted this year, and among other things, this new legislation makes effective custodial sentences much more likely in economic crimes. The new law also includes some interesting new possibilities that were not contemplated in the Competition Act, like asset forfeiture. Implementing this new law will definitely bring new challenges, but we firmly believe that once cartels are criminalized, a credible threat of imprisonment should deter cartel conduct.
So significantly more risk in Chile now for cartel conduct going forward. Okay, and I think we've been talking a bit about individual sanctions, but of course corporate sanctions are important as well. Manish, you folks at the DOJ recently announced an extraordinary corporate sanction remedy in a case that's kind of a game changer. Can you tell us about what that was all about?
That's very kind of you to say, Matthew, and I surely did not prompt you to ask that question. But the kind of unusual resolution that we recently entered into at the DOJ involves divestitures. So in connection with an investigation that the DOJ was conducting into price fixing in the generic pharmaceuticals industry, we resolved two corporate cases through a settlement agreement. And like many settlement agreements that you all are familiar with, it involved the imposition of various fines. So for the two companies that we resolved with, it was a combined total fine of $250 million. But in addition to that, there was a requirement that the companies divest the lines of business that were affected by the price fixing activity. So basically for those drugs, certain of the drugs that were price fixed as part of the conspiracy, the companies were required to sell those parts of the business to another buyer. And so the reason that we were able to negotiate this particular settlement has to do with the very heavily regulated context in which these pharmaceutical industries operate in the United States, and that may be similar to the regulatory framework in your jurisdictions, so I thought I would mention it. But in the United States, the consequences of a corporate conviction in the context of a heavily regulated industry, those are quite severe, because if a company obtains a criminal conviction in one of these heavily regulated industries, it's no longer able to sell goods and services into federal programs that serve the population of the United States. And as a result, that means that those companies would have to go out of business, essentially, because a major buyer of their goods and services, the United States, would no longer, would now be, they would be barred from selling to the US. And so we were able to basically negotiate resolutions that allowed these companies to continue operating, but they had to divest those segments of the business that were used to commit criminal activity. And so that's something that kind of a new, an enhanced penalty that we're hoping to pursue in other contexts.
No, that's fascinating. So, I sort of had to think outside the box to protect the public interest, but also to sanction them, to make it hurt for make their conduct have consequences.
That's exactly
and you're
right.
able to do. That's really amazing.
Yeah, I had nothing to do with it, but I'm always happy to talk about it.
Okay, let's turn to the group therapy session or part of our panel today, which is for some of our great panelists to talk about challenges in cartel enforcement. And we've been touching, Marissa, a bit on leniency throughout, but what do you see as the challenge in leniency as far as it relates to Spain going forward?
Yes. So, as you know, Spain, like other European agencies, we have a leniency program with immunity for the first thing and the possibility for reduction of fines for the ones that would come later and still offer significant added value in the sense of evidence that would help proving the infringement. And of course, that is supposed to be the key element of interest. But things have evolved over time, and I will not get into all the ways we have to protect leniency information because I think that is widely known. It has been there for a while, the limitations on the use of leniency statements. But recently Spain has become one of the jurisdictions with more damages actions, which was quite unexpected. There are damages actions because of the track decision of the European Commission, but also because of our decision on cars. Then there is milk, and then other things are coming forward. So at the beginning, there has been a lot of uncertainty about how much damages would be awarded, obviously, because there is a presumption that cartels cause harm, but there is no presumption about how much harm they cause, and this has to be established. By now, after thousands of different judgments at different levels, we have had the first 15 judgments at the level of the Supreme Court in the trucks case. So there starts to be more clarity also for those who have to advise companies about what is the possible cost of damages. And okay, they range. For instance, in our cars case, you have had like 50% of no damages at all because it was not sufficient the way companies have tried to prove the causal link and the damage. And then they were coming from 2% until around 15% or so. And in the Supreme Court for the trucks case, which may be specific to that case, they have been awarded, let's say, like, if you don't know better, then you get 5%. So it is, let's say, it is damages that can be a lot if you count in figures, but it is not a lot of percentage. Then what we do have is a public contracting ban. So for very serious infringements of our law, we can impose a public contracting ban. And we have issued now guidelines on how we would intend to impose it ourselves, because before we were sending it to another body who can do it for us. So we can determine the scope and the duration of that ban. And the interesting part about this is that, of course, our fines may be deterrent or not, but not being able to contract with the administration for some companies is a good deterrent for cartel infringements. So then immunity applicants that succeed are excluded from the public contracting ban, and also in the case that is directly by law. In the case of reduction of fines applicants, we have consistently exempted them as well, as a matter of fact. So let's say that leniency has a benefit, an extra benefit, which is quite substantial. And then I would remind that according to the European directive, immunity applicants do not have joint and several liability against victims with the rest of the cartel members. They only pay to their own victims. And I remind you that in Europe, we don't have punitive damages. We don't have treble damages. You cover the loss you have and the possibilities of gain. So we are touching upon the different things. So public contracting ban, leniency applies. We have compliance. Some compliance in some circumstances can decrease the fine, and it can be added to the reward for leniency. So we are fine-tuning lately what we are offering for leniency. However, as a general principle, we are not in the business of giving as much leniency as possible. Because if that was the question, I mean, we have had a public consultation on our leniency program this year, and we are studying the results. But you know, the game is not having as much leniency as possible. It is being able to get the cases, to prove the cases, and to still be deterrent, even with leniency.
Yeah. To calibrate the incentives in the context of all the other things that are going on, like debarment and private damages. And
exactly.
Yes, it's a very tricky game, and we have a lot of the same issues in Canada. So thank you. Amira, you're our private practice representative on this panel. What do you see from your perspective as the challenges in Singapore and maybe that might apply elsewhere?
Yeah, I think the one thing that strikes us is trying to ensure that we get employees to come forward, and there are a lot of difficulties when we talk about whether there's an incentive for anybody to come forward. First of all, I think there is this issue of having them comply, well, having corporations comply with more stringent requirements, and that really is, you know, in some jurisdictions there are developments where succeeding in a leniency application can be particularly difficult in terms of ensuring that they have to find the wrongdoing and punish the wrongdoing. And what we have found is that there is a lot of internal pressure for corporations to do that, but there is less incentive for the employee to want to come forward. And this is true even in a place like Singapore, where we have no criminal penalties at all, unless it's for obstruction of justice. Nothing against the individual. These are all substantive offenses against the corporation. But because for an MNC, if conduct comes to light in Singapore, it would have some sort of repercussion elsewhere. We find people do not want to come forward because they would be subject to criminal penalty elsewhere. So the difficulty, I think, is that trying to calibrate, encouraging people to come forward, but at the same time, making sure that they are in some way, you know, punished for their role in the wrongdoing. And so we have had many situations where we know that there is wrongdoing, but trying to get any employee to be a witness against themselves, I mean, that's an impossible task. And even in a place where there would be no repercussion for them in Singapore, whatever happens elsewhere is really what gets us. The second thing is the threat of private action damages, which has been discussed already. Again, in Singapore, this is not a serious threat because we only have follow-on actions and we also do not have punitive damages. But the effect of the threat of such litigation elsewhere has also meant that there is no incentive for corporations to come forward in Singapore, notwithstanding our less punitive laws, because this will just expose them in other jurisdictions. So it ends up being a situation where we can provide the best environment for you to come forward with the least possible pain, I guess you could say, for individuals. But MNCs will play according to the rules of the strictest regulator. And we already have very few cases, but it doesn't matter that we've put the conditions that are right for people to come forward. It really makes not much of a difference when it comes to a multinational corporation.
Yeah. So those sort of multi-jurisdictional challenges are obviously difficult for all of us in cartel cases when there are multiple jurisdictions involved. And Jorge, I wonder if you could talk about one of the biggest problems. Certainly, we feel it in Canada, and I know lots of our colleagues feel it, is where the evidence is located somewhere else, and you need to get your hands on it, and you don't have an avenue to do so. Can you just talk about those challenges for you folks?
Sure. Well, let me first start saying that international cooperation has been key for the FNE's cartel prosecution policy. We got seriously involved in the cartel working group about 5 years ago. I can't emphasize enough how much we have benefited from it. We encourage agencies, especially newer and younger agencies, to get involved. It's definitely a great resource, not only for trainings, as the ones we have done as part of the Back to Basics program, but also to have partners all over the world you can reach out to when you face difficult issues, as we all do in our daily work investigating and prosecuting cartels. ICN cartel workshops have been key in developing that network. International cooperation has been a key element for us, not only in training and sharing experience, but it has also been crucial to our investigations. In the aerial firefighting case I mentioned earlier, we received evidence seized by the Spanish criminal prosecutor. In a case involving the salmon feed industry, we received wiretaps obtained by the Dutch criminal prosecutor. And in the cartel case involving the transportation of cash and valuables, we were able to decrypt a flash drive with the assistance of the FBI. All this evidence obtained through international cooperation has been critical in building our cases. I believe there are some international cooperation issues that definitely deserve our attention. First, in an increasing number of cases, we are encountering decisions made by parent companies abroad that affect Chilean markets. When we request information from subsidiaries, they often use the corporate veil to say they don't have access to information of their parent companies. If you approach parent companies, they say they are not legally required to produce information to foreign agencies. The problem is trickier when you face companies that don't even have subsidiaries or legal representatives in your country, something that appears to be common nowadays in digital markets. And we all know using MLATs is costly, takes time, and MLATs are usually only available when cartels are criminal conduct. Second, we are increasingly facing allegations from foreign companies refusing to comply with requests for information invoking privacy laws. Even though privacy laws usually have gateways or exceptions for requests from foreign agencies, it's not always easy to agree with companies about how to interpret them, and usually you don't have an impartial third party to solve the dispute that arises. We all agree about the importance of privacy laws, but if they become an obstacle to investigate illegal conduct, we may need definitely to be vigilant and act together. And finally, problems related to service of process abroad. As I already mentioned, we recently brought the competition court, before the competition court, a cartel case in the cash and valuables transportation market. We directed our accusation not only to managers of the companies in Chile, but also to regional managers who oversaw the business in Chile and other Latin American countries and directly participated in the cartel, but who didn't have residence in Chile. The regional managers of 3 accused companies had residence in different countries, and one of the Chilean managers was relocated to a very remote country in Asia just towards the end of the investigation. We served process to all of them, but it was costly and time-consuming. So with company structures that increasingly involve international structures and individuals located abroad, this is an issue where we believe increased cooperation could be definitely useful.
And I think that makes some very good points, Jorge, and it's something that the international community needs to keep working on very hard to figure out ways to have evidence come across borders. It's a very tricky issue, but it's really important for a lot of jurisdictions like Canada, like Chile. So thank you. I know we started a bit late, but we're running out of time. So Our last little section will be pretty short, but it's ideas for the future, ideas for how to enforce cartel law better, or new ideas. And one of those we see certainly in Canada, I know in the United States, probably elsewhere, in our Securities Commission. They now have a fair bit of experience of paying whistleblowers. I think it's been quite successful in the United States. We're starting to see success in Ontario and Canada. Manish, what do you think about this as a way forward for cartel enforcers all over the world? I know some do it already, but as a new tool in our toolbox.
Yeah, so I have no firsthand experience with this because in our jurisdiction, there is no whistleblower program for competition law violations. What I have observed as a prosecutor is a reluctance often for witnesses to come forward and to report conduct because of the follow-on consequences of doing so, even with a leniency program. That is sometimes not enough of an incentive, especially if that putative whistleblower was not a direct participant in the conduct. And so, one way to address this, Matthew, as you've suggested, and has been pursued in other contexts in the United States, such as securities law violations, is to provide a financial reward to whistleblowers. But on the other hand, there are some issues with that because you are potentially compensating wrongdoers for illegal behavior. And so I would be very interested in hearing the experience or the thoughts of other jurisdictions represented on this panel about what their experiences have been or their observations in this context.
Okay, well let's go to Amira then, because I think they do it a bit in Singapore.
Yes. So in Singapore, you could get up to 120,000 Singapore dollars, which is about, I think, 82 to 83,000 euros, up to that amount, as a whistleblower. This is only available to an individual, not a corporation, because if you're a corporation, you should go for leniency. And they have successfully paid out. I'm not sure the amount exactly, that's the maximum, but they could have paid out less in a couple of cases. And what I understand is that in some of these cases where they've come forward, the quality of the evidence has been pretty good. So there is, that can be quite helpful. And of course, in our jurisdiction, in any event, individuals do not have that individual liability. So it's not like they have something to fear, they have only something to gain by coming forward and getting a reward. So it's proven to be quite successful.
The experience certainly in Ontario with our securities laws proven that for whistleblowers, often they're in very high-paying jobs, and if you're not going to compensate them extensively for blowing the whistle, they won't come in because they'll never get hired in the business again. So that's always an interesting consideration. Now, I think it's a great place to bring it to an end with our hosts. Spain, what's the situation here? Do you pay lavish amounts of money to people to come in and tell you about cartel conduct?
No, we don't pay for this. I think that there may be also a difference because the systems we are discussing are also different. I mean, normally in a common law system in which you have a first in for, the amnesty, and you don't have a second in or a third in, and then you have to go to settlements, or where you need witnesses in order to persuade a jury, and all that, you have a certain tendency to obtain what you need. In our case, as I was saying, since we have the SICA channel and other previous channels, we have a lot of tips from whistleblowers, and they have increased 33%. A lot of it is not useful, some of it is useful, but we have to be able to digest it. So if we were also paying, we would hardly do our job, I think, on other terms. Now, I don't think we would be able to pay these lavish amounts that we have heard, but the point is that when Manish was speaking, he was speaking about two kinds of whistleblowers. In our case, the whistleblowers are not known. We are not going to ask them to be witnesses because of the different system. But in particular, for the whistleblower that is somebody that could be charged with the cartel infringement, for us, we would certainly prefer to have leniency, because there is a possibility for the first in, but also for the second in, for the third in. And the important difference, and that's what I want to say, is that if you are under a structured system like leniency, you have duties, you have obligations, you have to cooperate in a certain way. So then we know that. It means that it also has consequences, and it means that what you are saying are leniency statements which can be then used by us as evidence. It can be used in evidence if corroborated by statements of the other party or by other evidence. So you need your witnesses, we need our evidence, and I think that that is also the difference in the systems.
Okay, great analysis to finish with. Excellent discussion. Please join me in thanking our great panelists for their discussion today.